Here. Further, the infringement of trademark will be discussed by my co-counsel. Now, the council want to state that according to Order 1 Rule 1 and 3 of the CPC, it gives power to the Honorable High Court to merge two cases to the cell together if they thinks that the case have the same facts and the parties are also common, which is here in the case where a suit for trademark and patent is lying, so that which can be heard together at the same court in order to save the time of court. Now, if your counsel is convinced with the argument, the counsel would like to move to the further issue. The order passed by the Act of PI manufacturing and selling separators, similar to the patented separators of WB corporations, amounts to the infringement of the patent rights of WB corporations. The right given to person in form of patenters, which is presented on page number 21 of the written submission of 9. The effect of the grant of patent is quid pro quo. Quid is the knowledge disclosed to the public, and quo is a monopoly granted for the terms of patent. Here, a patent once granted confers on the patent the exclusive privilege of making, selling, and using the invention if the infringing goods are made with the same object in view which is attained by the patented article. A minor variation does not mean that there is no piracy. A person is guilty of infringement if he makes what is in substance the equivalent of the patented article. Some trifling or unessential variation has to be given, which is very relevant to the present case, and also referring to a landmark judgment of Bajaj Auto Limited versus Trademark TVS Motor Corp, which is also mentioned on page 22 of the written submission. Which is written submission. A person is guilty of infringement if he makes what is in substance the equivalent of the patented article. Some trifling or unessential variation has to be given. Thus, in the present, can it is similar to of the WB corporations amounts to infringement of WB corporations patent 4.51, and thus PI can be held liable for infringement, and WB corporations and WBI shall be granted relief under section 108 and 109 of the Patent Act respectively. Now, I would like to discuss the last issue of the council. The orders passed by Bombay High Court in restraining for the groundless threats are not justified. In order to, according to section 106 of the Patent Act, the most essential ingredient of the groundless threat is that there should be no infringement in order to prove that there was a groundless threat. But in the present case, as proved, there was an infringement of the patent of WB Corporation. These groundless threats do not stand. But in order to prove it further, the council would like to prove the evidence submitted to the court are legally acceptable, which were submitted by Mr. Chintamani and industrial investigator. First of all, I would like to say, evidence means anything by which an alleged matter of fact is either established or disapproved, which under section 3 of Indian Evidence Act defines all documents including electronic records produced for inspection of the court. Such documents are called documentary evidence. Also to mention, under section 45 of Indian Evidence Act, which supports the admission of report of an expert, and here Chintamani, an industrial expert, has completed a full investigation, and therefore later on he has submitted the report, which is incorporated in the facts of the Moot proposition, which found that there was an infringement by Prudent Industries. Also, in the case of Regina versus Christio and Wright, the electronic records are allowed as evidence, which is helpful for the present case where Mr. Chintamani is submitting photos and videos of his investigation.
Do you know under which section of the Evidence Act electronic records are admissible?
Actually, under section 3 of Evidence Act, it is told that all the electronic documents can also be treated as an evidence if the court needs to. The council would like to further prove that the cease and desist notice passed was justified. Cease and desist notice. Cease and desist notice, basically an informal warning of infringement issued by WB corporations. In present case was justified as there was an infringement of the Patents and Trademark Act, and therefore no groundless threat was created by plaintiff. It was a warning for which there was an infringement. Also, in the case of Calcutta High Court, Dolphin Laboratories versus Kappa Pharmaceuticals, it was held that if plaintiff on his part proved that there was an infringement on the behalf of defendant, then threats for the legal proceedings are justified, which is relevant to the present case. So, summing the argument, here the groundless threats which the order passed by Bombay High Court in restraining the groundless threats is not justified. And if the bench is convinced with the arguments, my co-counsel will be able to follow.
What is the argument?
The co-counsel will be arguing first of all upon the infringement of the Trademark Act, that the use of Zico by prudent industries was infringing the rights of WB corporations, as well as whether the court found the claim filed by before the High Court for revocation of patent proceedings and before the IPAB are maintainable or not, and whether the claim of PI for compulsory licensing from WB is just. Much obliged.
Council would be dealing with three issues. Firstly, that the use of the mark Zico by the prudent industries and separators is deceptively similar to the trademark of Willy Incorporation, that is Zico on its separators. Secondly, that the counterclaim filed before the High Court and the revocation of the patent proceedings into the Intellectual Property Appellate Board are not maintainable. And thirdly, the claim of prudent industries for compulsory licensing from the Willy Incorporation is not justified, and the controller of the patents is not justified in hearing and deciding such a claim. To prove the first contention, the Council has further divided the contention into four sub-contentions for the convenience of the honorable court. Firstly, there is a likelihood of a confusion among the prospective buyers. A person may buy the goods of prudent industries thinking that it is the brand which may not be the case. In the case Mahindra and Mahindra Paper Mills versus Mahindra and Mahindra Limited, the Supreme Court held that all the factors which are likely to cause deception or confusion must be considered in combination. Examples: the nature of the market itself, the class of customers, the extent of reputation, and the chip trade channel. Considering all these factors, in the present case, there is a likelihood of confusion. As Zico and Zico, they sound the same, they appear the same, and they are used for identical products. The separators, they are also sold to a large as well as a small scale industry in India. Considering this, that some customers, they are likely to get confused as the words, they sound the same and they appear the same. Secondly, there was an investigation by Mr. Chintamani, who is an industrial investigator. He clearly concluded in his investigation that prudent industries was infringing the trademark of Willy Incorporation. The report submitted by him can be considered as authentic as he submitted under an affidavit under an oath. The reports consisted of a detailed report along with the transcripts of the communication and secretly taken interviews with some of the employees of the food industry. Thirdly, the use of the trademark Zico was not an honest concurrent use by the food industry, as it had earlier in 2008 approached the Willy Incorporation for the grant of license for separators. This implies that it was already aware about the existence of a phonetically similar word Zico, yet it chose such a word.
You're saying that the defendant, in this particular case, deliberately copied the word Zico, right? In order to mislead customers, right? When did the defendant first start using the word Zico, the name Zico itself?
Much obliged, Your Lordship. The facts, they are silent on this case that it's not mentioned in the facts. The Council will also be dealing with this issue in the next convention. So it shows a phonetically similar word for the sale of identical products. This indicates a malified intention on the part of the prudent industry. In a case of Kalanikethan versus Kalaniketa, a suit for permanent injunction restraining the defendants from dealing in sarees under the trade name Kalanikethan was filed. It was held that the trade name was not descriptive of sarees and the plaintiff was entitled to relief. Similarly, the word Zico is not descriptive of the trade. It is an inventive word. So the likelihood of food industries selling the separators under similar name as that of Validity Corporation is very unlikely. Fourthly, Zico is a well-known trademark in India. Had the patent been working under the Trademark Act, Zico since 1920, the Intellectual Property Appellate Board would not have registered it, firstly. And secondly, moreover, food industries did not oppose the registration of the trademark of the word Zico when they were given the time to do so under the Section 29 of the Trademark Act. They only opposed it when the deceptive similarity of the word was found out by the Validity Corporation. If the Honorable Bench is satisfied with the first contention, the Council would like to proceed to the next. Much obliged. The second contention deals with that the counterclaim filed for the High Court and the revocation of patent proceedings before the Intellectual Property Appellate Board are not contained. The Council would like to bring to the notice of the Court that the burden of proving the patent is invalid or liable to be revoked is on the person who is filing the petition or counterclaim for the revocation. Thus, the liability of proving the patent number 42231 is invalid is on the food industry. Secondly, the Council would also like to refer to the case of Alois Morgan versus Yogesh Mehra and others, wherein the Supreme Court held that it would be right to say that the principles analogous to Section 10 of the Code of Civil Procedure empower a court to stay a suit pending before it if the cause of the parties before it are substantially the same, and the court dealing with the earlier action would have the jurisdiction to deal with the later action as well. As filing of a revocation of the patent before the Intellectual Property Appellate Board and questioning the validity of the patent as a counterclaim for the High Court is a repetition of procedure. And as the matter in issue in both the cases substantially the same. And this can lead to the wastage of the court resources, and also it might end up in conflicting decisions. According to Section 10 of Code of Civil Procedure, it is contended that the court may pass a stay on the proceeding of the Intellectual Property Appellate Board. And my learned counsel is also seen to agree with the same in the written submission. The Council would also like to shed some light on the fact that by the virtue of the Patent Act of 2005, a person interested may approach either of the two forums. By the use of the word or under the Section 64 of the revocation, it is contended that the revocation of patent can be filed either in front of the High Court as a counterclaim or in front of the Intellectual Property Board. And it cannot be, the similar proceedings cannot go on in both the forums. In the second sub-contention of the second contention, the Council would like to state that there is no valid reason that the revocation of the patent on number 42231 should be the patent number 42231 under Section 64 of the Patent Act lays down the grounds for the revocation of the patent. But in this instant matter, none of the grounds meet the requirement of the for the life that the revocation of the patent should be given. Thus, there was an inventive firstly. This is because firstly there was an inventive step as well as novelty in the formation of the separator. It is a new and effective machine to separate contaminants from raw materials for drug manufacturing and raw material products, and such raw materials may be in free-flowing liquid or solid form. It is a patentable machine, duly registered and working in various other countries. The customers, they have no complaints with regard to the functionality of the product, and they are still demanding this product, even though the prices are costlier than the food industry. The separator got registered in India in accordance with the sections 43 of the Patent Act. It has further been taken that the validity that the various other countries, developed countries like United Kingdom, USA, Russia, even there the patent has been granted to them. Doubting the novelty of the patent could imply doubting the validity of the patent in other countries as well. If the Lordships are satisfied with the second contention, the Council would like to proceed with the next.
One question at this point. The Indian patent, the 2007 patent, which is number 4 something, that was granted in 2007.
Yes.
Prudent seems to have been in the business of manufacturing separators since 1920. Correct? So, doesn't that make it something already known or something that's been used in India for a really extended period of time, and the patent was granted much after? Does that have any impact on the novelty of the
follow-up to this question, was the Groundless patent premised on a sufficiently large or accounting step? The question is, if there is evidence of a prior form of separator available in India, is this new form sufficiently well in advance, ahead of the originally available here? And in if so, in what sense are they
Much of that,
advanced?
much of that. In this, food industry had they might be dealing in this business in 1920, but the patents they were registered under the section. They were registered by the Intellectual Property Appellate Board. During all had the patent had not got had the patent already been had the separators already been in existence, then they would not have gotten registered under the Patent Act under by the Appellate Board firstly. And
Just to correct you there, the controller is the one who grants the patent, not the IPA. So, first of all, it's a presumption that if a patent is granted, the due process is being followed by the controller in searching for prior art and all that, and the patent is being granted, assuming that it is a new and inventive product. The question actually stems from this. There is this counterclaim and invalidation pending now. BI has filed, or the defendant has filed a counterclaim for invalidation. That is also pending right now. In this case, prima facie, from my opinion, if this has been in existence since the 1920s, we might be more inclined to hear the invalidation grounds rather than. That's just an opinion. I just wanted to hear what you have to say about that.
to prove that there was an inventive step in the sale of separators or the production of separators by the delivery corporation, the council would like to state that prudent industries at first bought the products of the Kuntal butter products first bought the product from the prudent industries. Later on, it was selling the product at 10 lakh rupees, which is a minimal amount. Later on, it shifted its choice from the separators of prudent industry to that of the delivery corporation. Now, there has got to be some reason, there's got to be some difference in the manufacturer that was willing to pay rupees 14 lakhs for the sale of the same separator. Had it been a similar inventive step,
Irrespective of the fact that they were willing to pay a higher price and they're willing to go with delivery, that still doesn't answer the question whether the inventive step was sufficiently large enough to have been called an inventive step and program, and for which a patent could have been promised. Right? And do you understand what we're trying to do? So you still need to say that if there were separators in existence in India before, that the separator that delivery was created is of a sufficiently much more refined and a much more advanced form, or on some of the claims at least.
Firstly, prudent industries are approached for the license of the patented product. Had they been producing the same product, they would not have approached for the license. There was an inventive step, firstly because they approached for the license. Secondly, the shift of the claims, shift of the choice from the prudent industry to the delivery corporation had been done. If your lordships are satisfied with the second contention, the council would like to proceed with the last part. The council humbly submits that the claim of prudent industries to grant of compulsory license is not justified. The three conditions laid down under the section 84(1) are not fulfilled. Firstly, the reasonable requirements of the public is subjective clause. The short duration from the grant of license in 2007 till the application filed for the compulsory license in 2013 with the subsidiaries in various other countries, it was still able to sell off 2 lakh separators in India. If the delivery corporation is given more time, it will be able to meet the demand of 20 lakhs. Secondly, taking into account the cost of the developing the separators, its effectiveness, the research involved, and the import cost of the separators, the cost of separators is not unreasonable. The product was found to be very effective, and the users never had any complaint with regard to the functionality, and they were still willing to buy the product. Thirdly, the separators are being supplied in India.